Very good evening, everyone. Good evening to all. So, I welcome you, each one of you, to my class on the case laws on Mens Rea. So, let's begin with this session. So, let's start with my brief introduction first. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Here is the link of my profile of an academy. So, make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions. And at the end, I have shared my code, that is Khatri10, which you can use to get free access of all the special classes available on an academy app. So this was about me. Very good evening, Ashutosh, Aprajita, and everyone, those of you who have just joined. So I request now everyone, please be attentive, and this is going to be interactive session. So make sure if you have any question in relation to Mens Rea or IPC which is not clear to you, feel free to ask in the comments. Student, one important announcement. These are the 9 special laws which is in your paper 1 for UP PCSJ. So if you are finding it difficult in any of these laws, I have already covered all these acts in my special law series, which is in my special class, which is basically completely free. Okay, so I'm done with the explanations. I'm also done with the MCQs as well. So you can find all these classes in my profile of Unacademy. So now coming to this class, what we are going to discuss today is the topic, one of the most important topic of in the Indian Penal Code, and that is mens rea, which is one of the most important essential of the crime. So before starting this topic, which is basically a maxim, mens rea, if you have any questions in your mind, even before starting this topic, you may ask. Yes, anyone? All good, Aprajita. How are you? Okay. So I'm starting this topic now. So the first thing is, students, this is a Latin maxim. The first thing which you need to notice about this topic is that it's a maxim, okay, and a Latin one. Now coming to the meaning of this maxim. So the meaning of this maxim is guilty mind. Now, students, you usually get confused with the topic of mens rea and intention. Now, what is intention? Intention is the desire of the mind. Now let's have a look on both these terms and let's find out some differences. See, mens rea is guilty mind. Okay, so basically guilty intentions. But intention is the desire of the mind. Intentions may be good, intentions may be bad. So intentions may be good, intentions may be bad. So the good intentions will not come under the category of mens rea. The first concept of this class. Okay, mens rea means your guilty mind, and when it comes to intention, intention is the desire of your mind, which may be good, which may be bad, but the bad intentions are the part of mens rea, which is guilty mind. Okay, now coming to this concept of mens rea, which is one of the most important essential of crime, do we need some other essentials as well to commit a crime? The answer is yes. The very first essential is the person, which is defined under section 11 of the IPC. The second one is mens rea, which is guilty mind. Then the third one is actus reus, which is again a maxim. And mens rea and actus reus, both these terms has not been defined in IPC, students. Now, what is the meaning of actus reus? Actus reus means the consequences of human conduct which is forbidden by law. And the last essential, which is injury, that is defined under section 44. Section 44 of IPC defined the term injury. And there are 4 important terms basically total 5 important terms which you need to remember. The very first key important term of section 44 which you usually ignore is the term illegal. So the injury must be illegal. Read with mind, illegal with body, illegal with reputation, illegal with property. So any harm to the mind, to the property of a person, to the body of the person, to the reputation of the person will fall under injury. Now coming to our main topic, that is of mens rea. Ashutosh, we are going to discuss the topic. There are no MCQs involved. Okay, there are no MCQs as of now. All I'm going to explain, and if you do have any questions, you may ask in the comments. Okay, done. Now coming to in the detail of this topic of mens rea. Now let's take some examples. One of the best example to understand the concept of mens rea is theft. That is basically your section 378. Now theft is one kind of an offense which cannot be committed if there is no mens rea. You cannot commit this particular offense without mens rea. There are no exceptions at all as far as this particular offense is concerned, which means there are offenses. For example, when it comes to section 300 clause 1, the intention, the role of intention, mens rea plays an important role. Intention to cause death. Okay, so there is a list of offenses where mens rea is must. Okay, but there are certain exceptions as well where mens rea is not required. For example, kidnapping. Now coming to the essentials of kidnapping, the person who has committed the offense of kidnapping, that person, there is no need to prove mens rea on his or her part. The reason is because in guilty intentions, mens rea is not one of the essentials of kidnapping. And one of the landmark judgment in association with this concept is your R versus Prince, 1875. A landmark judgment which I'm going to discuss just after 2 minutes. Okay. Now coming to the some other examples. For example, traffic regulations. That is again an exception of mens rea. Okay, so there is no need to prove a guilty mind in case of traffic regulations. Offenses relating to weights and measures, in that case also there are exceptions. Okay, now coming to some case laws, interesting case laws, some important case laws which are related to the concept of mens rea. If you have any questions till now, you may ask in the comments. Yes, Aprajita, bigamy is again one of the exceptions. If any husband has committed the offense of bigamy, okay, that is basically the second marriage, there is no need to prove that he has guilty intentions. Okay, and the person will get the punishment. Now coming to the very first case law, that is your R versus Prince, the very first one. So let's discuss some, let's have some facts before. What are the facts of our case? Student, before going through any of the judgments, all you need to focus on the 4 major points of any particular judgment. The very first one is the facts, the material facts of the case. Then there comes to the role of the issue. What was the issue in that case? What was the issue that has been framed by the court? Then coming to the third point, that is your judgment, that what the court decides. And the last but not the least, one of the most important, the reasons why the court decided that. What are the reasons to support that judgment? Because every order needs to be a speaking order. You need to give reasons. Similarly, if you are answering anything in your mains examination, then you have to state the reasons for that answer. And the same rule goes for your interview as well. Whatever you are answering, you must have some important points to support your answer. So let's start with R versus Prince. The very first one, the facts, the important facts of that case. So there is one boy named Henry Prince. Then there is a girl, Annie Phillips. Now the thing is, As per to the facts, Annie Phillips was a girl who was under the age of 16. Now, Henry Prince unlawfully taken Annie Phillips out of the position and against the will of her father uh, to get married. Now, the thing is, students, when it comes to kidnapping, okay, if someone is minor, their consent is immaterial. You need consent of their parents. Let's have some interesting example. Go back to school. Whenever there is a school trip, usually we get those forms that we need signature of the parents, the consent of the parents. That can be okay. Do I have any questions? Okay. Now the question was, can we take your child from to a location called Manali, okay, for a trip, for a holiday trip? So if the parent consent, then only the school can do that. So similarly, if the father is not giving permission, all the essentials of kidnapping from lawful guardianship has been fulfilled. Now, the movement, see, the kidnapping is of two types. The very first one is your kidnapping from India. The second one is kidnapping from lawful guardianship. Now, Henry Prince has basically completed all the essentials of kidnapping from lawful guardianship. But there was one more important fact in this case, and that was that Henry Prince actually was not aware with this fact that the girl was minor. The girl lied about her age to Henry Prince. And now the thing is whether Henry Prince will get the punishment of kidnapping from lawful guardianship or not. That was the final issue. So first, I've just told you the material facts of the case. After that, I've told you what was the issue, whether Henry Prince will get the punishment of kidnapping from lawful guardianship or not. Now, before coming to the judgment, if you want to answer, I can have look on your comments. Exactly, Aprajita. Exactly my point. Yeah, the consent forms. Always do remember, whether you are studying criminal law or civil law, this rule will remain the same. The consent of the minor is immaterial. Okay, there's a famous quotation as well, that the minor is law's favorite child. The reason is because once you are a major, you can do some acts, and you basically are mature enough to know the consequences of your conduct. But in case of minor, that is not the case, and that is why law protects the minor. So that's the basically idea. Now the question is whether Henry Prince will get the punishment or not. Anyone who likes to answer in the comments? Aprajita, even the concept of misrepresentation will not fall on the minor. Okay. Now let me tell you one extra point here. I hope you all have heard about the rule of estoppel, section number 115 of Indian Evidence Act. I hope you all can recall that, the estoppel. Now, the concept of estoppel cannot be applied against the minor. Now, the question is, sir, why not? The reason is very simple, because you cannot make minor liable directly or indirectly. And that is the reason that even the doctrine of estoppel will not be applied on minor. Okay. Okay, Aprajita has answered, no sir, Henry would not get any defense and Henry will be punished for kidnapping. See, now the thing is, let me give you a formula of IPC, that whenever the question is whether this particular offense, so in our case, kidnapping from lawful guardianship, has been committed or not, okay, all you need to do is, if the essentials, for example, when you have a look at the essentials of kidnapping from lawful guardianship, the very first one is about the age of the girl, and that is she is minor. Okay, as per to the facts, the girl was under 16 years. So which means the first essential has been fulfilled. Now the second one, without the consent of the guardian. So in this case, that was without the consent of the father, as per to the fact. So that also has been fulfilled. Now coming to the third one, out of the guardianship. So that is also fulfilled. Now in that case, the Henry Prince has already committed the offense. Henry Prince has already committed the offense, so in that case, he will get the punishment. Why? Because when it comes to kidnapping, kidnapping is an exception where mens rea is not required. So this was your first case, R versus Prince. I hope everyone is clear with this. And if yes, quickly give me a thumbs up. I'll move to the next judgment, that is Queen versus Tolson. Okay, now coming to the second judgment, that is basically Queen versus Tolson. Now we will follow the same chronology. That is, first I will go with the facts, then the issues, then the judgment, and then the reasons. Now coming to the facts. So as per to the facts, the very first fact is that a marriage took place. So husband and wife. Okay. After that, the name of the husband was Tolson. So husband deserted his wife. Okay. After desertion, the wife and her father made some inquiries, and his elder brother, the elder brother of the husband, told them that he had been lost in somewhere in America. Okay. Now, in that case, the wife consider herself widow and get married to another person. So W get married to H1. And after this marriage, the husband appears. The story, the facts of this case actually sounded like a Bollywood movie, but this is what it is. Okay. So in that case, the husband returns. Now coming to the status of this marriage. What is the status of this marriage? Now, before framing the issue, let me tell you the law as well. The law says in that case, the wife should wait for 7 years. The law says in that case, if the husband has been lost, the wife should wait at least for 7 years. And after 7 years, if the husband did not come, then she may enter into the second marriage. But if the wife enters into a marriage before the expiry of 7 years, then the second marriage will not be considered as a valid marriage. And that's the law. Okay. Now, in our case, she actually waited for, I guess, 4 to 5 years. Okay, let me cross check the facts. Yeah, she waited for somewhere 4 to 5 years only. Okay, and after that she got married. Now these were the facts. Now coming to the question that courts needs to be decided, that what is the status of this marriage? What is the status of this second marriage? And you now know the facts. Now you know the law. Now please do answer in the comments. What is the status of this second marriage? Yes, please. Do participate, students. Aprajita, waiting for your answer. Whether the wife will get the punishment of bigamy or not. Whether the wife will get the punishment of bigamy or not. Okay. Now I'm answering the question as I have not got any response. So I'm answering this now. The answer is the wife, the W, will not get the punishment of bigamy. Now the question is, why not? Coming to the last part of this landmark judgment, why she is not getting the punishment for bigamy? And the answer to that question is because there was ignorance of fact. There was ignorance of fact which can be excused. So basically, the first point which you need to know about that is that bigamy falls under the exception of mens rea. The second reason here is that the wife will get the defense under section 79 of IPC. All the essentials of section 79 has been fulfilled. How? The answer is the first thing, whatever this W did, the wife did, that was something which was justified. Why it was justified? She waited for somewhere around 4 to 5 years. The brother of the husband only confirmed this, that the husband has been lost and you must consider yourself as a widow and you can get into the marriage. But in reality, the husband was alive because he returned. In that scenario, the very first thing is that whatever the wife did, that was justified and it was under good faith. She had no knowledge about husband. So good faith, justified, and the third important point is that it was ignorance of fact, not ignorance of law. Ignorance of law is no excuse, but ignorance of fact may be excused. And that is why she will not get the punishment of bigamy. I hope this is clear. Done? Now coming to the next case law, students, the third one. So the third case law which I'm going to discuss now is Nattu versus State of MP 1966 Supreme Court. Okay. So before that we discussed R versus Prince, Queen versus Tolson. Both were the English case laws. Now this is basically an Indian case law. Okay. I'm repeating the citation again. Nattu versus State of MP 1966 Supreme Court. Now first I'm going to tell you the facts. After that, in the same chronology, we are going to frame the issues, then the judgment and the reason. Now coming to the facts of this case, students, there was a person called Nattu who basically was a dealer in food grains. And he sailed without the license. So basically, if you are running a shop and you are selling grains, that person needs to have license. Okay. Now, when Lathulal got to know about this, that there is some requirement of license, so he went to the concerned office and he asked about the license. Now, the person who was sitting there, he gave him the form to fill. Okay. Now, Nathulal was illiterate and he thought that this form only is basically what the license is. And he kept, Nathulal kept this form in his almirah, and then finally he started running his shop. Then one day, the police came and they asked for the license, and Nathulal showed nothing but this form only. And then obviously it was not a license, but Nathulal pleaded that he was illiterate and he thought that this form only is the license. Now the court needs to be decided because he was running his shop without license. So whether Nathulal will get the punishment for that or not. So these were the facts and the issues. Now coming to the judgment. Anyone who likes to answer? Okay. Now coming to the judgment. Now, Nathulal was acquitted. Acquittal. The reasons was simple enough that There was no ignorance of law, because ignorance of law is no excuse, but there was ignorance of a fact which has been again excused. So, because Nathulal was illiterate and he thought he is having the license, that is not ignorance of law, that is an example of ignorance of fact which may be excused. So, all the essentials of section 79 has been fulfilled again, and Nathulal will get the acquittal. So, that was your Nathulal versus State of MP 1966 Supreme Court. So in this case, basically the Supreme Court acquitted under the Essential Commodities Act 1955, and bona fide belief is a valid defense. So these were the judgments, students. So let's conclude the class. So this is the link of my profile of Unacademy. This is the link of my Telegram channel, and this is my code Khatri10. So let's crack PCSJ with Unacademy. These are the upcoming batches. As you can see, there's a regular linking course 2023. There's a rapid revision for Uttarakhand Judiciary, which has been started from, which is going to be start from Feb 1st. There is going to be rapid revision for West Bengal Judiciary, which is going to be start from January 23. A good news, students, judiciary notes are launching on 30th of January. So you will get subjective theory, quick view charts, recent cases and landmark judgments, legal maxims, integrated MCQs and PYQs, mains question and model answer. Celebrating Unacademy is celebrating Republic Day, and you can get 20% off on all the judicial subscriptions. So this offer is valid till January 28th. Prices are rising by 20% on January 31st. So prices hike coming soon. This is from 1st of February. There is UP Judiciary Prelims mock test series, and these are the features. And there are going to be 3 tests, one on 3rd Feb, 5th Feb, and 7th Feb, and you can use my code, that is Khatri10, to get 20% off, and this is just 500 only. There are 3 full-length mock tests, and there are unlimited attempts as well. So that's it from my end. See you in my next class. Till then, yes, it's time to say peace.